Employment discrimination mediation and how COVID changed the dynamics of it. A conversation with mediator and conciliator Marci Jordan. This is our topic for today.
Welcome to the Lawyers and Mediators International Show and podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcast. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent.
Hello and welcome. My name is Natalia Łowska-Czajka. I'm based in Warsaw and I am an advocate, mediator, and arbitrator.
Hi, everybody. This is Mac Pierley, attorney, mediator, and arbitrator. And we are joined again by our dear colleague who had just recently recorded with us a last topic on housing discrimination, mediator and conciliator, Marci Jordan. And Marci, you're back. For
Yes.
folks who might be tuning in this episode, please share just a little bit about yourself again.
Okay. Currently, I work for a state agency, Texas Workforce Commission Civil Rights Division. And in our division, we handle employment and housing discrimination cases for all the state of Texas, whether it's a state agency or a private employer. So we handle those complaints, either mediate, conciliate, or investigate all those complaints and hopefully work out a resolution. So
Yes.
that is it. I also own Jordan HR Consultants, which is a consulting firm to help small businesses establish an HR department, get it up, getting running, designing anything they need to be successful, as well as access to me to answer any questions they may have during the process of having employees, pretty much.
Yes. And you are speaking out of your own personal capacity, correct?
Yes,
Not out of the
yes,
capacity of
no,
your official government job. But
yes.
great and happy to have you again.
Thank
And
you.
this time we're switching to a topic that's a little bit different from the last topic, which was housing discrimination.
Right,
Now we're talking about employment discrimination mediation
right.
and how COVID-19 has changed the dynamics of it. Could you lay the foundations a little bit? First off, what is employment discrimination mediation? And tell us what typically happens in such a thing.
Okay. Employment discrimination, basically what our agency handles and I personally handle is anything that falls into Title VII, age and disability. Title VII is your race, color, national origin, religion. Age is, anything, any person over the age of 40. Disability, any type of disability. Sexual harassment falls under the category of sex. So we handle a wide variety of cases where if somebody's on the job and they feel like their rights have been violated, then they file a charge of discrimination or a case with us with TWC Civil Rights Division. And then the first step once they file it is to go to mediation. If both parties agree, then they get to sit and have a 4, 5, 6 hour conversation with myself, the other parties, to see what we can do to keep the dialogue going, reach a resolution, everybody gets an agreement and closure and can move on from charges of discrimination. And it impacts not only the person that filed the charge, but also the business is impacted as well because they do have to spend time, money, energy to investigate, make sure they have all the documentation, and come to the table prepared to reach a resolution. That is a requirement. So do a whole lot.
And I believe that this sort of mediation can help a lot, both to
Yes.
clear up the situation, the air, to vent for people, to make the situation better between coworkers, between a
Mhm,
particular person and the employer. But I
mhm.
would like you to specifically tell us what sort of cases have you encountered, what cases you have been dealing with, and what people are complaining. Because I strongly believe here in Poland, I've been also dealing with family law matters. I know that sometimes people think that they don't meet the threshold. They think,
Right,
oh, maybe someone is doing something wrong to me, but maybe it's not discrimination. Maybe they just don't like me. So,
right.
what would you say? How? to empower people to
Hmm.
believe that they have a good case, that they are right, that they are treated unfairly, that
Hmm.
they have ways to follow, to fight for their rights, and to be
Hmm.
treated fairly.
Okay. We tell anybody, excuse me, we tell anybody if they feel that their rights have been violated to go ahead and file a charge of discrimination with our agency, and then we will take the time to hopefully mediate it because we encourage everybody to mediate or investigate it and make a determination. And with the guidelines, our state guidelines always mirror federal law. Federal law is the end all be all. So with state in the state of Texas is Chapter 21, which is the labor code. So it's the same criteria. In order to file a charge of discrimination with our agency or with EEOC, they must have at least 15 employers. And that is the threshold for any cases. Now, there are some cases where it's 20, and that will be like a family leave act or disability. But if they have less than 15 employees, we have no what they call jurisdiction. We can't do anything with those kind of cases except for one type of case. As of September 1st, 2021, the Texas state legislature passed a bill, which is now state law, that if anybody is being harassed in the workplace, they can file a charge of discrimination with TWC, and it doesn't have to be 15 employees. It could be 2 employees or whatever the case may be, which is really, really good because that does protect the employee. But we have found out the employers, a lot of employers, didn't realize that this law went into effect. What are the ramifications? What can we do to protect ourselves from frivolous complaints? And also, if they do get a charge, how do they go about rectifying the situation? So, there is a lot of different things that we do handle. We always encourage people just file the charge or call in and talk to any of us, including myself, to ask us, is it truly something that you need to file, or did I answer your questions and you're okay? So that's usually how we do that. We always encourage them to file.
Thank you. So a similar question I had asked, a similar question that I had asked was for housing discrimination. How
Hmm.
does the, you know, employer in this case trust that you're going to be impartial when you are the mediator,
Right.
because you're working basically for a organization that is
Hmm.
both potentially enforcing the law, but
Right.
at the same time is trying to be a deal maker to help
Hmm.
people settle their disputes. So how can both sides trust that you'd be impartial?
Right. That's a very good question. We get a question about that all the time because if a person files a charge of discrimination, sometimes they feel like we're their advocate and we are a neutral third party. We advocate for the law and the resolution. So we let the complainant know, get your documentation together, present your case. This is your opportunity to have a uninterrupted conversation with your former employer. We also let the employer know that if you don't feel like it's discrimination, this is the perfect opportunity to discuss why you feel this way and present your documentation and have that conversation. So a lot of employers in the state of Texas do adhere to mediation. They love going to mediation because they know that it's impartial, it's fair, and also we are free. So they can't beat that. Plus, myself and my cohort, we're trained. We go through numerous trainings, whether it is mediation techniques or the law, to make sure that when we have to explain the law, we're explaining it correctly, accurately, and let parties know, okay, this is the situation, this is how you go about rectifying it. And also the reputation of our agency and myself and my counterpart. They know that we have a reputation that's going to be fair, unbiased, straight to the point, and let them know we're here to do the work. If you're ready to do the work, we will do the work. If you're not ready to do the work, then there's nothing we can do. There's
And
nothing.
we gathered together today not
Mhm.
only just to briefly say what the employment discrimination mediation can be, but you also mentioned specifically that COVID played an
Yes.
important role in what happened in the employment environment. Can you tell us what you see and
Mhm.
later on what the remedies to that can be?
Okay. As of March 2020, here in the United States, life changed as we know it. And with the changes of COVID, just handling how do we maneuver what is going on, who's an essential employee, and also remember if they do have a disability, their rights are not, put on the shelf just because they are an essential employee. How do we navigate any type of disability, accommodations, have that conversation, as well as if somebody contracts COVID, how do we handle that? Or they may have long term effects or long haulers, as they call them, with COVID, the after effects of that. And as well as we were navigating the vaccine mandate, how employers are supposed to administer that, what happens, the exceptions to the rule, disability or religious beliefs. So that conversation definitely just took over all the employment discrimination. Plus, people are afraid, didn't know what to do, scared if I tell my employer I'm tested positive, are they going to fire me? I don't have any leave time. So it just really changed the whole tone and conversation of how do we maneuver this? How do we have these unique and different conversations? How do we tell them, okay, it's not employment, it may be something with OSHA, HIPAA laws. So all these conversations that we normally did not have now come into play. And it's important that anybody that mediates employment discrimination cases be able to fully understand and know how each individual case is applicable to what they are alleging, but more importantly, have that compassion, because in this whole situation and dynamic of rules, regulations, laws, and everything else, people sometimes forget it's a person. And the person that filed the charge of discrimination is nervous, they're scared, and you have to treat them with compassion and respect. Employers are nervous, they don't know what to do, how to handle it. And even though it may be an employer, there's still people behind that employer. Or as I say, there's a person behind the title, and I don't deal with titles, I deal with people. So all of those came into play, and we're still navigating how we handle it, but these conversations have come into play, and you have to make sure that you fully address those issues and concerns that either party may have. So different conversation all the way around. Plus, currently we do everything virtual. We don't do any face-to-face mediations because of people don't feel comfortable sitting in a closed room for a couple of hours, don't know the vaccine status of either party. So we have found that Microsoft Teams, Zoom, Adobe Connect, or telephones works great. So those are the things that definitely change. I do miss the face to face, but I understand and I'm good with that. I'm okay.
Yeah. So, do you think that one of the ways COVID changed things also was the need to constantly now keep up with the changing rules and regulations with regards to COVID?
Hmm.
Because COVID policy is still kind of evolving as
Right,
we speak, right?
right.
It's not, we're all going through this together for the first time in what, 100 years,
Hmm.
with this global pandemic.
Right.
And so I'm guessing that this might have been quite a burden on mediators like yourself who deal with workplace discrimination, and all of a sudden you find yourself dealing with this thing from left field that nobody was talking
Hmm.
about just 2 years ago.
Right.
So how have you been able to, and you and your colleagues, how have you been able to sustain this and keeping up with it? And one more thing,
Hmm.
as we all know, the president was trying to basically do a vaccine mandate that was going to affect employers with at least 200 or more employees,
Hmm.
and that was going to be administered by OSHA. And
Right.
then the Supreme Court came along and basically neutered that, and so
Hmm.
and that kind of went away. And I think they pulled back a lot of those proposals. But I can only imagine
Hmm.
of how your office and how
Hmm.
you, as a discrimination, expert, would have been dealing with all the things that would come out of that. So can you talk a little bit about that, about the constant changes that are always evolving in this field now?
Right. It's so important to stay connected to what is going on in the federal government, EEOC, because they would send down information from us like every other day. OSHA. So it's important to find out, was it a burden? I would not say it was a burden. It was just due. what's doing prudent planning. You got to be able to have that conversation. What is going on? What is correct? What's not correct? And the whole 9 yards behind it. And since I am a person that loves to be connected with information, I want to be on top of everything. It wasn't that bad. So I ended up kind of like being the person that assimilated the information on this is what's going on in the federal government. This is what they're saying. These are the guidelines. Okay, wait a minute. Hold on. Change this guideline. It's this guideline. So it was a unique animal, and it's still being unique because the the requirements that the Biden administration had passed was 100 employees or more, and that was with private sector. Now that did get overturned in the Supreme Court, but just within the last few days, they reinstated the vaccine mandate for federal employees. So a lot of private employers that may have contracts with the federal government, they will probably adhere to that vaccine mandate. So this is another thing that we have to have that conversation about in regards to what's going on, these changes. This is how it's going to be applicable to what we do, what we say, how we investigate cases. So it's an ongoing situation. It's never one size fits all. It's never, okay, fine. This is what they established last year. We go by this. No, it's been changed. So you have to stay on top of it. Is it daunting and overwhelming? In the beginning, yes, because it was scary. It was really, really scary, and we didn't know what we were dealing with and how to maneuver it. Then it came down to, okay, now we got a vaccine. How do we talk and have that conversation? Who's impacted? Who's not impacted? And I did have cases where somebody alleged that they got fired because they didn't want to get the vaccination. So you have to explain, okay, this is the situation. When did the vaccine mandate come into play? Is it applicable to you? Is it applicable to your company? Does your company fall into that many employees? So it's still ongoing. And you always have to stay engaged with the federal agencies that's passing down information, state agencies, or the state legislature passing down information. So you have to, it's with any type of mediation, to be a very good mediator, you have to hone your craft. You always have to work on your craft, know what's going on. And it doesn't make a difference what type of mediations you do. You have to stay on top. Or, as I say, you got to be on the cutting edge, because if you don't, you're going to get stale and you're
Yeah.
not going to be effective in mediation. So
Yes.
it's a lot.
No, thank you. It's a lot to keep up with, and
Mhm.
thank you for fact checking me. It was 100 employees, not 200.
That's
So
okay.
can't keep it all straight. It's so much coming at me at
Yes.
one time. Yes, please,
Yes.
Natalia.
Oh, yes. I wanted to ask you because, again, COVID changed a lot.
Mhm.
I'm bringing us into the world when we suddenly realized that on many occasions we do work
Mhm.
remotely quite well, but on the
Mhm.
other hand we were conflicted with our home duties, homeschooling of children
Mhm.
and all that. We all know that it brought a lot of stress. People dealing with distant working were also
Mhm.
dealing with family violence on many occasions.
Yes.
And I wanted to ask you whether you, in your capacity as a person helping within this field, noticed more cases of discrimination, or how was it perceived? Was it that because of COVID, everybody
Mhm.
was really afraid of losing their jobs and they said, no, no, I'll stay quiet. I am not going
Right.
to report my employer
Mhm.
because what happens? I am the only bread earner in the house.
Mhm.
Uh, it's already very hard. So shall I just stay quiet and do nothing? What's your observation on that?
Um, there was a slowdown right when COVID hit because people were working remotely, or they were furloughed, and or they were central employees, and they pretty much adopted of, I'm not going to rock the boat. But when we started to kind of get a idea of what we're dealing with, then the cases started to increase, and the majority of the cases I've seen, or a lot of the cases, was failure to accommodate. The employers didn't understand that if a person has a disability and they need reasonable accommodations, it doesn't matter if you're an essential employer. you still have to have that conversation, and you still have to find ways to accommodate them. So we saw cases like that, or being fired for no reason, or being laid off because companies were struggling money wise. And why did I get laid off compared to this person? Was it my age? Was it my gender? Was it my disability? Was it because I was pregnant? So we're seeing more and more of these cases where people are asking questions, and people now are going, I'm going to rock the boat. I'm going to ask these questions, right, wrong, and different. I want to ask these questions. And they find that in mediation, they're able to say what they need to say, and it's uninterrupted, and it's a safe place because they know that anything they talk about in mediation is confidential. And also too, the employer is fully aware, and I make sure that they're fully aware, anything that is shared in mediation, you cannot use it as retaliation, because retaliation is against the law. So, we're getting more and more cases of people being, filing, going, this is not right. So yeah, we stay pretty busy, extremely busy.
Thank you so much, Darcy. And to close up, could you take the next 30 seconds and again just let people know how to get in contact with you and a little bit again
Right,
about your website? I have it
right.
shared on the screen for folks who might be listening.
Okay. I decided through my time mediating and talking to employers, a lot of problems that came about was they didn't have sufficient, inadequate, or ill prepared HR staff. And it didn't make a difference what the title was, or if they had symbols behind their names or letters behind their names, as my husband would say. They did not understand what their charge was. It was status quo. And from that, and talking to a lot of attorneys that's representing employers, it came to be, I'm asked questions like this all the time in mediation. Why not do a consulting business so that way they fully understand what their rights and responsibilities are as a good employer? How to recruit employees, because you can't recruit certain places and not others. That's discrimination. Salary, questions that you ask in interviews, because if you ask the wrong question, it's discrimination. And I've had cases where somebody had asked about their familial status, and it was a woman. You cannot do that. That's discrimination. To how do they handle investigations after the employee is hired? Conflicts. Was it really a personality conflict, or was it discrimination? So with that, I said, you know what? There's a need out there, and I have the expertise and knowledge. Why not give small businesses the opportunity to have a HR department created for their personal needs, because one size does not fit all, as my tagline would say, and be able to create an HR program that's tailor fit to them, and then have access to me whenever that they have any just mundane question or any type of questions. It doesn't matter if it's during the workday, on at night, weekends, because some companies work 24 hours, and be able to get that response to them. And as they grow, make sure that they understand when you hit that magic number, as I say, of 15 employees or more, to make sure that they follow the guidelines of the state statute and federal law. So it was important. And from that, that's why I decided this is something needs to be done. I'm the person to do it. Plus, I like
Got
to
it.
talk and help
And
people.
that's jordanhrconsultants.com.
That is correct.
Thank you so much. We'll put that in our description on the episode. And closing out, everybody, appreciate you so much, Marcy, for coming back and talking to us
Thank
some
you.
more.
Thank
First
you.
about housing discrimination, and now about employment discrimination
Yes.
mediation. All right, everybody, signing out. This is Mac Pierre Louis, attorney mediator.
Natalia Ovska-Czajka.
And Marcy Jordan.
All right, take care. Bye bye.